Mr. Girding, I'd like to focus on the Commission's proposed climate rule, which I believe would have a dramatic effect on public companies. There are estimates that put just the initial compliance cost at more than $100 million for some companies. In your rulemaking process, how have you assessed the effects of these costs? What will the effects of these costs have on public companies, particularly the smaller and more medium-sized companies?
Congressman, the rule proposal that you're referring to contains a rigorous economic analysis that looks at the benefits and costs to public companies and public companies of all sizes. That being said, we, as part of every economic analysis and every rule proposal, we solicit comments on the economic analysis. We gather comments, and we've received a lot of comments on the benefits and costs in the economic analysis, and we are carefully considering those in any recommendation.
So do you factor in, do you ask, do you calculate what the cost potentially would be for a public company? Is that a part of the equation, how many dollars? Because that affects the viability of a company, all costs do.
The economic analysis would factor in all costs of the rule on public company reporting, including compliance costs with the disclosure regime.
Have you worked with any other agencies that undertake climate-related rulemaking, such as the EPA, NOAA, the Department of Energy, the FTC, or for that matter, just any other agencies?
Congressman, we consult and talk to a number of federal agencies in our rulemakings, but all of our rulemaking recommendations are based on our statutory authorities and our notice and comment rulemaking, including the comments that we received in response to the rulemaking.
So in a case like this with climate-related rules, in essence, you go it on your own, okay? The proposed rule would also impact private business that are in the value chain of a public company. Public companies that are required to report emissions data will turn to their downstream suppliers, such as farmers and ranchers, to calculate and report their emission data to those companies. We've seen public companies shift their inputs to larger operations that have the resources to track climate and emissions data. Do you know the number of public companies with Scope 3 targets?
Congressman, I don't have that particular statistic with me now. I will note that we have received a number of comments on the impacts of the climate rule proposal on the suppliers that you mentioned, and are taking those comments very, very seriously.
I'd like to know, if it's possible, the number of companies that your people believe would be impacted. And has there been an analysis conducted on the volume of private businesses that would potentially be forced out of the supply chain as a result of this because their bigger partners simply have to turn to someone else?
Well, I want to note, Congressman, that the climate risk disclosure proposal would apply only to public companies. There are provisions in there that would apply to, would require certain disclosures by public companies that may impact other companies, and we're carefully considering all the comments we've received on those.
And I appreciate that, Mr. Girding, because you're a part of the federal bureaucracy, and you know organizations tend to shift their responsibilities and their costs to someone else. I'm just concerned that in public business, the least able to compete, the folks who are having the greatest challenges being a part of the economy, are the ones who will get shoved out of this. Mr. Girding, if climate-related information is material to a company's public operations, or I should say a public company's operations, is that company already required by the SEC to disclose that information, completely absent of the rule? If something is material, they're supposed to say so already, correct?
This is a common misconception, Congressman. The SEC rules do not require public companies to disclose everything material that happens to them.
Has the materiality standard served our capital markets investors well so far?
The materiality standard that we continue to follow is that articulated by the Supreme Court, and we continue to follow the statutory mission that we've always followed, which is providing.
Gentleman, time has expired.
This is fascinating, Madam Chair. I yield back.